reluctantly admitted to being responsible for. Here now is the report.
Perhaps he did not know it at the time, but by the time the son of veteran journalist Macharia Gaido took this video of his father being bundled into this white pro box, it would form a critical part of the evidence of what transpired Wednesday morning as it gained widespread attention on social.
I was blocked by a civilian car. I was waiting for it to move out. Some two other men on my left side where I was seated and my son was driving. Opened the door and tried to pull me out. They did not identify themselves, so I refused to get out of the car and expected my son to drive away. They followed us.
Go ahead, please, pause.
And we
Yes.
to come to current police station.
It is here at the current police station that Macharia and his son Andrew tried to seek refuge and report this navy blue Subaru Forester, registration number KCB 847S, which had blocked them and tried to kidnap Macharia. Unknown to the father and son was that danger lay in wait, as this white pro box registration number KBC 725J emerged and its occupants pulled Macharia out of his car and into the pro box. Even more concerning are the police officers, clearly marked in uniform, who are seen assisting to push Macharia into the white pro box.
They drove me down Lanata Road, up to near, I think around the turning of Lanata South Road, where they stopped. They made a few calls. I don't know to do it, but I gather they were talking to their superior.
NTV conducted a search on the white pro box, registration number KBC 725J, and found that it is registered to a one Stephen Kimathi. But interestingly, the make of the car on the motor vehicle copy of records is different. It instead states that the make is a Toyota Corolla. There may be an explanation for this, as a closer look at the car's number plate reveals that the letter C appears doctored, raising questions about the legality of the vehicle used to bundle off the veteran journalist, as well as the legality of the individuals who carried out the act. Further, NTV carried out a search on the Subaru Forester that initially blocked Macharia and his son as they left their home. Watch what happens when the search is carried out, because strangely, the National Transport and Safety Authority NTSA portal prevents me from searching for the vehicle and does not yield any results.
I have never had to go through abduction, kidnapping by people who I do not know whether they are police or whether they are terrorists. A 19-year-old young man going through that, whom his father abducted in a very brutal, violent fashion, must be very traumatizing. It is traumatizing for my mom, in Mary, at the age of 95, getting this news that her son has been abducted and doesn't know by whom.
As if the abduction of Macharia Gaido wasn't hard enough, the National Police Service, via their official channel, stated that the whole incident was a case of mistaken identity, claiming they mistook Macharia Gaido for blogger Francis Gaido.
We cannot be held. I think we were there during the struggle against the one-party dictatorship. If we resisted more, who are these ones?
When asked whether he intends to sue the state for damages,
we also note Macharia Gaido's demands that the SCTNEWS needs to command responsibility. We have historical case where we've done this.
Sadly, Macharia Gaido's incident isn't different from what other Kenyans have had to endure in the past few weeks since the anti-government protests began.
If it means going to the streets, that's what we are going to do. And that's why we agreed that as media fraternity, next week Wednesday, we are issuing a 7-day notice starting today Next week, Wednesday, we are calling for a nationwide protest.
The Kenya Editors Guild wants immediate action taken against those who attempted to forcibly seize the veteran journalist.
The IPOD headquarters were the final stop for Macharia Gaido and his legal team as they sought to complain over today's abductions, which they rubbish as a case of mistaken identity. This is a case they say they are willing to take to the state's doorstep as they complain over the trauma he suffered earlier today. Ngena Kirori, NTV, Nairobi.
Yes.
The video we found at paragraph 10 of the fifth interested parties replying affidavit dated 6 January 2025.
Yes.
Mozart Casino Jackpot. Zungusha gurudumu la furaha. Kuwa mshindi. Mozart Bet.
Mr. Goyo, please play the last 15 seconds of that. Can anyone hear clearly what that gentleman says?
He exclaims.
Wewe unataka what mwizi hapa? Oh. Wewe unakaa mwizi hapa. Yes, Council.
So that previous found in paragraph 12 of a supporting affidavit dated 26 December 2024. The court should also note that that is the second petition who to date is still suffering trauma, mental anguish, and we were unable to get any of his statements as regarding this matter. He's been unable to speak to it.
Yes, any others?
The last one, the Lordship.
Yale yamesemekana mambo ya abduction tutakomesha, ndio vijana wa Kenya waweze kuishi kwa amani na vile wawe na nidhamu na wawe wangwana, tuweze kujenga Kenya tukiwa pamoja. Tunakubaliana?
Council Mango, what is the relevance?
Yes, Your Lordship. This is in the fourth interested parties, further affidavit dated 23rd January 2025, at paragraph 6, where the President himself said that they would stop the abductions. Your Lordship, that brings us to the end of
The person in that video is not before this court. And when I asked you the relevance, you said it was, let me stop your time. It was in the Kiswahili language. There are multiple ways to interpret what that phrase would mean. Tutakomesha means to stop, means we will stop. I'm not certain, and because of that, I will not have it introduced. Yes, Senior Counsel.
I think the video is more than has been shown, and the link is available. There is a request by Raila Odinga that abductions of young people do stop. That is what Dr. William Ruto is responding to.
Yes.
And it will give us the basis in our submissions to show that this I don't know coming from the respondents.
Yes.
It's not true, because the entire state up to the highest level, if you, my Lord, denies us that footage, then we cannot be able to make robust submissions, especially in the face of refusal by the duty bearers
Yes.
to come to the court and say, this is what is happening.
Without that context, Senior Counsel,
Yeah.
because what has been brought is 4 seconds without what you are referencing previously, so that I'm able to appreciate the context in which that statement was made. I cannot appreciate it.
Allow us then to show more than that, because we have it. They were just saving the court's time. I have provided a link in my affidavit,
Yes.
and the link is full. It's not partial. But this was fashioned for the court to save time. Allow us to show the entire video. It takes a while, but we can show it. Can you please?
Mr. Nyamodi, you are rising.
My Lord, that is the point I made about the application that is before you this morning. The petitioners have elected to show you the video. The evidence that they have chosen to support their application is what they have shown you. Post your Lordship's ruling, there is no opportunity for that evidence to be improved. Your Lordship has given a ruling based on what you have been shown, and there is no other basis for that ruling. You have decided that you are not admitting it. Let us proceed from there.
I think we also deserve to be heard. If the respondents are saying they have a right to be heard under Article 50, so do we. And I have, I'm still on my feet, in case you can't see.
Just adding on to what my
Counsel,
brother said.
not only, I do not in any way tolerate that. The way we conduct matters in courts is you wait for a natural break or to be called upon. You don't speak over counsel, especially not over senior counsel. So please retake.
I agree,
Counsel,
I'll wait.
Please retake your seat. Senior counsel, continue.
Most obliged. So we are also seeking to be heard. The paragraph 6 has the link, and the link has the full video. It begins with Right Honorable Raila Odinga and ends with Dr. William Ruto. And I would seek that it be shown fully, because the link is not partial, and the link is Azimio TV. And these are matters in the public domain. This is a case, my lord, where we'll have to show a pattern and to show that the state has knowledge at the highest levels to be able for the court to determine the two issues, to secure the liberty, to inquire into the legality.
What I can assure you, senior counsel, because if you are stating that the link is full, when I retire to write, I will do this all again. Okay. I'll click on every single link. If it is full, then I think your concern is
addressed.
Would be addressed. Yes, counsel.
My Lord, the links that were shared over the weekend. And I didn't see any link that included the portion that senior counsel is referring to. What was shared is what we are seeing on the screen today.
Well, it's not a big deal. If when I retire, I click on that link, because the link will not change. If I click on that link and it doesn't give what I expect, I think my Mr. Guyo is preempting. Okay, let's do it that way, Mr. Guyo. No, it's okay. Let's do it that way. You can save me time. But do we have that affidavit? You have the link? In PDF?
The same link.
Yes.
Is contained in the affidavit of the 8 interested party at paragraph 21.
The challenge is my Mr. Guyo is not, you have to log in.
I believe you have given guidance.
Yes, let's just leave it at that.
Let us move.
Let's just leave it at that. Yes, Council, we have about an hour left.
Yes, Your Lordship, that brings the end to the presentation. And I've been inviting Councillor Ochel Dudley to submit on issue 1 on compliance.
Hello, issue 1 is a fairly straightforward question, and it's whether the respondents have complied with this court's orders of 30th, 31st, and 8th of January. The simple answer, my lord, is that no, they have not complied. 2 of the petitioners, my lord, are heading to their 2nd month in captivity. And none of the petitioners was brought before the court, as the court had ordered. Instead, my lord, the state, using public resources, chose to deposit them around the country, endangering their life even more, and contrary to the court's orders. So the answer, the straight and simple and narrow answer to issue 1, my lord, is that no, the respondents are in continuing violation of the court's orders. They've refused to the 7th and 8th petitioners, and they did not comply with the conditions that the court has given. That, my lord, is the whole issue. Thank you, my lord.
Thank you.
My lord, on the second issue,
yes,
I'll submit shortly to allow senior counsel Martha to proceed with the same, is whether an order of habeas corpus ought to be issued. My lord, you're still aware that 2 petitioners are still missing? As much as my Lord has given leeway, dispensing the fact that the Inspector General of Police and the head of DCI should not, we still do not have answers, and the duty bearers have failed to produce the 2 petitioners before this honorable court. My Lord, the only way to ensure the safety of these 2 petitioners, where their current whereabouts are unknown, is that we must hold the duty bearers accountable.
Yes.
They have access to public resources, and they cannot come and tell this honorable court that they do not know. My Lord, your brother Justice Mbruna, in the case of the Law Society of Kenya and 3 others, versus the Attorney General, the Constitutional Petition E-467 of 2021, in his holding on the right to habeas corpus,
Yes.
he stated that the right to an order of habeas corpus can be described as the greatest guarantee of human freedom ever devised by human beings. Its importance rests on its being the absolute safeguard against arbitrary and lawless state action
Yes.
on its citizens or aliens lawfully within the borders. He further stated in paragraph 57 that under Article 3 of the International Convention for the Protection of all persons from enforced disappearances, states are obligated to take appropriate measures to investigate any acts of enforced disappearance and bring those responsible to justice. My Lord, the respondents before you today have failed to comply with those court orders, and therefore the writ of habeas corpus sought in this notice of motion application ought to be issued. It is our position that the hand of the respondents is in the incalculable cases of enforced disappearance and illegal detention. The same is for the reason that the said unlawful acts by the security agencies are tied to those who have criticized the government in one way or another. My Lord, to date you have not received any information as to the extent that they have taken to assure or to provide and produce the 2 petitioners that are still missing, nor any reason as to why they are lawfully being detained or at all. And therefore, my Lord, this writ is the only guarantee that will assure the safe return of these 2 petitioners. Thank you. Meet please the court.
Yes.
I want to add on to that and say that the scope of the writ of habeas corpus is twofold.
Yes.
To produce the body and to inquire as to the legality of the detention. If you look at Article 25 of the Constitution, it merely lists habeas corpus as a non-derogable right. It is not described, but when you go to the Judicature Act, it guides us that statutes of general application of England are applicable. And as a matter of fact, this writ originated in the United Kingdom and has spread across the world. It is now under the 2010 Constitution that we are having numerous cases of habeas corpus. We had a few during the Nyayo era.
Yes.
And it is you, my lord, and other judges that are going to help us develop a body of case law to guide the writ of habeas corpus. You are referred to the case of Stephen Mureithi,
Yes.
whose facts are totally different from these ones, in the sense that when the application was made, Mureithi was long dead. He had been released from captivity, had died through natural attrition, and the application was being brought after the promulgation of the 2010 Constitution to redress his rights. So the court properly ruled that the writ was not applicable. But its ruling, it's helpful to those facts, not to all other cases. If you look at Article the page has disappeared, but I'm going to get it. Okay. Article 165, which establishes the High Court.
Yes.
In particular, subparagraph 3 to clause 5, the High Court shall have unlimited original jurisdiction in criminal and civil matters. Even if I don't go on to show about the court's jurisdiction on the issues of fundamental freedoms in the Bill of Rights, the fact that this court has original jurisdiction in criminal and civil matters brings issues of the writ of habeas corpus under the ambit of the court. And Article 51 also provides that any person who is detained or held in custody is entitled to petition for an order of habeas corpus. And then this is governed by the Criminal Procedure Code on how to deal with it.
Yes.
So my submission is that the court first has a duty to order the production of that person, and that does not exhaust the writ. And the person is produced alive or dead.
Yes.
in the 1987 case of Barak Karanja by Justice Schofield in Eldoret, Karanja was produced dead after exhumation of several graves in Eldoret. So in Kenya, persons have been produced alive and also dead. The second is the court to determine the constitutionality or the legality or otherwise of the detention. I want here to point out, my lord, that detention has become, abduction rather, has become an epidemic.
Yes.
In this country since last year, and the court may wish to take judicial notice that there's been abduction of both foreigners and locals. And we are in court on the abduction of, initially it was 7 persons, but now we are dealing with almost 9 persons. And that petitioner 2 to 6 were coincidentally released just before the IG, the CS Internal Security, and other top officers were to appear before you.
Yes.
We will also be showing that there is a pattern, that instead of releasing these individuals, producing them in court, they are released elsewhere, and then the duty bearers come to court, wipe their hands, come to court and say, we do not know, we understand they are now home, as a coincidence. So it is upon, my lord, to stamp the authority of the law, which will be stamped by this court, because the people of Kenya have given the courts the mandate to oversee the rule of law and to settle disputes between those in authority and citizens. It is unheard of for anybody to suggest that this court should now say, after all, they've shown up, even if all had shown up, and not all have shown up, the court cannot discharge its duty before determining the issue of the legality and pronouncing itself as a guide to stop any further such actions. Now, to conclude, because I think I was time-bound and I may be exhausting my 5 minutes, the court did raise the issue of some of the respondents. And I've noticed that the DPP is saying, I prosecute, please don't bring me here. I want the court to know that he too is a duty bearer. He can direct the police. We have not had any, he has not come to court and say this practice is wrong. All of them are just quick to tell the court, remove me from your presence. Let me not explain.
Just a moment, Senior Counsel, just a moment. Mr. Chochi, I may forget. Am I correct? I remember seeing, I think I saw something from the DPP, the person of the DPP directing, I can't remember whom, I just glanced at it somewhere, directing, I think it was DCI to investigate abduction, is that correct?
Yes, my lord, we are written to the IG.
You've written to the IG? Okay, that's it, that's fine, thank you.
It is up to my lord to find whether that is enough or whether a public directive that this practice must stop, and whether there is admission by the authorities that indeed it is them. Because when a duty bearer comes to court to say, I don't know, or it wasn't me, in a way it's contempt of court. it is actually obstructing the ability of the court to do its work. So I want to urge the court, habeas corpus is in the nature of an inquiry. Look at the facts of the case, look at the circumstantial evidence, look at the statements of the Kenya National Commission on Human Rights, a constitutional body. Look at the entire evidence and pronounce yourself authoritatively, not just for the petitioners before you, but for our country, Kenya, so that we may feel safe and the duty bearers may not continue to draw salaries while folding their hands and merely saying it wasn't me.
Senior Counsel?
Yes, Your Lordship. I'll proceed with issue 3, together with the first and second interested parties. Your Lordship.
You have another 45 minutes.
Yes, Your Lordship. We would be fully relying on the video evidence that has been presented before you. For Your Lordship, we have the 5th and 6th petitioners, further affidavits dated 13th January 2025, as well as the 4th petitioner's written statement dated 13th January 2025. Your Lordship, and it will come to your attention,
yes,
that there are similar facts as to how the abduction happened. But even before we get to the how, Your Lordship, you'll establish from their statements and from the affidavits filed by the first and second interested parties who will speak, that the petitioners are known critics of the government. Second, Your Lordship, the enforced disappearances and or abductions happened in broad daylight. Thirdly, Your Lordship, the abductions happened with motor vehicles that bore fake registration plates. I'll quickly read that the second petitioner was abducted by a black Prado, registration KCF 035M. That is to be found at paragraph 12 of the first interested parties replying affidavit. It's getting the date. The affidavit is dated 6th January 2025. And at paragraph 18, Your Lordship, the first interested party, upon conducting the investigations, found that that registration plate belongs to one Joseph Maina Mwangi, who lives in Nakuru.
Yes.
And that motor vehicle is in fact a probox, and the said individual is in fact a bishop. And he indicated that on that particular day, his motor vehicle was parked. Your Lordship, the said record has been confirmed by the 8th respondent on the affidavit file based on the copy of records. They have confirmed that it indeed belongs to him. Your Lordship, quickly, the third petitioner was also abducted by a white probox, registration KCA 397R, that is also to be found at paragraph 25 of the first interested parties replying affidavit.
Yes.
And at paragraph 33, the first interested party indicates that the vehicle is a tipper. However, Your Lordship,
Interested party indicates the vehicle
is a truck, a tipper, in fact, a tipper.
Yes.
But at paragraph 6 of the 8th respondent's affidavit, that is NTSA, they do record that it is a saloon motor vehicle that is green in color, registered to one Wario Board. Finally, Your Lordship,
registered to
one Wario Board, that is as per the Wario Boru kill, which they have annexed the copy of records. Finally, the 5th petitioner, who was from the 3rd interested party's offices at the point of abduction, was abducted by Subaru motor vehicle KCG 089A.
KCG
089A. That is to be found at the first interested parties replying affidavit at paragraph 51.
Yes.
At paragraph 59, from the investigation, they do confirm that the vehicle belongs to one Catherine Kalaju,
Yes.
who's a resident at Maua, and the said copy of record has been confirmed by the 8th respondent. Basically, Your Lordship, what we're telling you is that these abductions happen by motor vehicles that bore fake number plates. Further to that, Your Lordship, I'd invite you to look at paragraph 61.
Just a moment. Yes.
Paragraph 61 of the first interested party, the replying affidavit,
Yes.
where Your Lordship, the neighbors of the 5th petitioner
Yes.
allude to a break-in to the 5th petitioner's house by men who are armed and the said happened during the full glare of the day. The men identified themselves as police officers, and it did not take 24 hours, barely 24 hours later, the 5th petitioner disappeared. So, Your Lordship,
4 hours
later,
yes.
the 5th petitioner, after having a meeting at the 3rd interested party's offices, disappeared, Your Lordship. I would not want to reiterate because, Your Lordship, I know when you retire, you read the affidavits. But the affidavits by the fifth and petitioner, as well as the fourth petitioner, give a blow-by-blow account of how the abduction is. And, Your Lordship, you will notice a similar trend, which will be highlighted by the interested parties. Your Lordship, they were taken to detention centers. Your Lordship, from the clips, you heard about places with black cardboards. You'd see the same appearing in their statements. The second interesting party will talk about the humanity, how they were tortured, Your Lordship. And as such, Your Lordship, this honorable court can only come to one conclusion: that the petitioners were, one, in custody of the first, second, and third respondents, and further, to reiterate submissions by senior counsel, that it is only the first, second, and ninth respondent who ought to bear the burden of producing now the seventh and eighth petitioners before you. I'd invite Mr. Kinoti from the first interested party to present.
May I presume?
Yes.
I apologize, I came a bit late.
Good morning, Dr. Amino. How are you?
All right, thanks. It's a pleasure to appear before you all. I do apologize. I came late. I appear for Kituo Sheria, the sixth interested party. Donna, I pray that you give me a little time later on to say something.
I think someone would said Mr. Kinoti first.
Yes, Your Lordship. Mr. Kinoti, then Ms. Madunga, then Dr. Amino would follow.
I would like to put in that word for my learned friends.
Mr. Kinoti.
Senior counsel.
My Lord. Yes. On the part of the first interested party, only have 5 minutes to the issue of the case. My Lord, just to put it on record, we have filed an affidavit replying to the affidavit dated the 6th of January 2025. Yes. The further affidavit dated the 1st January 2025. Bundle of authorities, my Lord, dated the 8th of January 2025. And the supplementary funding, my Lord, dated the 25th of January 2025. Yes, my Lord. The third issue relates to what is the standard of proof and whether that standard of proof has been met in this matter for the court to issue orders of habeas corpus. My Lord, just as a background, my Lord, in our affidavit, my Lord, dated the 6th of January 2025, as alluded to by counsel for the petition, we have set out in detail, my Lord, what our preliminary investigations found out with regard to circumstances surrounding the abduction of the second to seventh petitioners, my Lord. My Lord, when you retire and look at the affidavit, you will notice that those abductions, my Lord, were carried out within a span, my Lord, of less than a week. The earliest, my Lord, yes, being the 7th petition on the 18th December. Yes, and the last being, my Lord, the 5th on the 24th. My Lord, they were also very well coordinated and organized, my Lord. Carried out out in broad daylight by persons, my lord, in circumstances where motor vehicle number plates were identified using altered or concealed number plates, whereby, my lord, upon search, it was discovered that those motor vehicles were using fake number plates. Yes. Also, my lord, the persons were armed, dressed in civilian attire, and had covered themselves. Furthermore, my lord, all this happened across the country, my lord, ranging, my lord, from Embu, yes, Kikuyu, my lord, Ngong, Lolongo. My lord, that coordination, my lord, organization, all those abductions were carried out without the abductors being stopped, being arrested by members, my lord, of the second respondent, my lord, which is the only organ, my lord, that is mandated under the Constitution, my lord, to ensure the safety and security of Kenyans. My lord, the second to sixth petitioners were also, my lord, then released in parts of the country, so the abductors, my lord, not being stopped, arrested by members of the National Police Service, which is the only organ, my lord, mandated to ensure the safety and security of Kenyans. My lord, with that background in mind, my lord, yes, the standard of truth with regard to habeas corpus, my lord, was set out by your brother Justice Murray, my lord, in the case of Law Society of Kenya versus AG and two others, 2018 EKLR, my lord, which we have put, my lord, as an authority. My lord, bearing in mind these are not criminal proceedings, at paragraph 33, my lord, the court set out that the standard of proof is an unbalanced probability. My lord, however, the burden, my lord, while it rests on the petitioners, in cases of enforced disappearance such as this, my lord, where a pattern has been established, my lord, we have set out authority from international courts that in such a case, my lord, the burden shifts, my lord, to the organ of the state that is mandated to ensure the safety and security of Kenyans, to rebut and provide information as to the whereabouts of those, my lord, who are missing. My lord, if you look at our bundle of authorities, dated the 25th, my lord, of January, yes, we've set out, my lord, a decision by the Human Rights Committee in the case of Garcia, yes, which looks, my lord, at an equivalent application for habeas corpus brought under Article 6.1 of the ICCPR, my lord, to which Kenya is a party. And in that case, my lord, when you retire to look at it at paragraphs 9.3, my lord, and 9.4, the Human Rights Committee notes that in cases of enforced disappearance such as this, a characteristic element is a refusal to acknowledge, my lord, the detention and to reveal facts and whereabouts of the person. So, my lord, a characteristic element, my lord, of enforced disappearances Yes.
is the refusal to acknowledge detention and to reveal, my lord, the fate and whereabouts of the person. And therefore, my lord,
yes,
there is information, there is no information asymmetry between the respondents and the petitioners. Consequently, my lord, in this case,
so there's no information asymmetry.
Yes.
Shouldn't it be there is an information asymmetry?
Yes, my lord, there is an
yes. Yes.
Between the petitioners and the first, second, third, and ninth respondents with regard to the whereabouts, my lord, of the seventh and eighth petitioners. In that case, my lord, the burden then shifts to the respondents to provide you, my lord, with clear information and evidence to rebut
yes,
the assumption that they are the ones holding the petition of my lord. So, my lord, with that background in mind, the burden now clearly rests on the respondents to provide with clear information to rebut that presumption. My lord, you notice from the replying affidavit filed by the first, second, third, and ninth respondents, that burden has not been satisfied. They merely indicated they are conducting investigations, and they are not the ones holding the petitioners. That is not sufficient.
yes.
My lord, we've also put in our authority the case of Vasquez. My lord, that is a decision by the Inter-American Court of Human Rights.
Please spell Vasquez.
Vasquez, my lord, is V.
Yes.
A.
Yes.
Z. Q. U. E. Z.
Thank you. Bye.
Where the Inter-American Court of Human Rights, my lord, also discussed the issue of evidence in cases of enforced disappearances. My lord, when you retire to look at that decision, my lord, and that decision, my lord, is one of the main decisions in international human rights law with regard to enforced disappearances. The court also notes the importance, my lord, of circumstantial or presumptive evidence in enforced disappearances in view of the information asymmetry. My lord, at paragraphs 131, the court notes
yes,
that circumstantial or presumptive evidence is especially important in enforced disappearances since it is characterized by an attempt to suppress information about kidnapping or whereabouts of the victim. My lord, in this case, the petitioners and the first interested party have set out a background to how these abductions took place, the organization, the systematic manner, the coordination that triggered the burden.
yes,
And the first, second, third, and ninth respondents to explain, to rebut that they are not the ones holding those positions. That has not been done, my lord. And therefore, my lord, it's our submission that the petitioners have established sufficient
yes,
that orders of habeas corpus ought to issue in this matter to the first, second, third, and ninth respondents to produce the 7 UK petition. That is what we got.
Thank you. There are about 20 minutes to go.
Yes, Madam.
Yes.
On the part of the second interested party, the Commission filed an affidavit in support of the petition. The same is dated 6th of January 2025.
Yes.
Together with a further affidavit sworn by Mr. Kamanda Mucheke, the head of Complaints and Investigations Directorate in the Commission. The same is dated 21st January 2025. And the Commission confirms that on 13th of January 2025,
yes,
the second to sixth petitioners came to our offices and recorded their statements. And on 14th January 2025, we accompanied them to the office of the DCI for them to also record their statements. In accordance with the orders that were issued on 8th of January 2025, my Lord, you'll note from the affidavits that the Commission has condemned the recent surge of abductions in the country.
Yes.
And the same is clearly highlighted in the Commission's press statement that was issued on 26th of December 2024. The same is annexure number 8 of our affidavit dated 6th January 2025.
Yes.
Within which the Commission was calling the 9th respondent to embark on investigations and present a report on the whereabouts of the second to sixth petitioners. My Lord, I wish to highlight the contents of the preliminary investigations that were conducted by the Commission.
Yes.
With respect to the abductions of the second to sixth petitioners. My Lord, we noted that all of them were government critics.
Yes.
Who have been active in the digital space, specifically the X platform. And my Lord, as highlighted by Council for the first interested parties, the petitioners were abducted by armed masked men. They were blindfolded and handcuffed during their captivities. My Lord, the petitioners were questioned about their criticism towards the government by their captures.
Yes.
My Lord, the petitioners were also moved to different locations within the Republic of Kenya.
Yes.
They were shaved. The hair on top of their heads was shaved without their consent. My Lord, the petitioners during their captivity were stripped naked for a couple of days and their clothes were returned to them after being washed.
Hi. Naitwa Captain Africa, aka Chief wa Usalama. Me I know about gas. Na gas ni Africa's. Come hivi I show you why. Chipo mwitu who slap. Lakini gas mwitu, tricky. Tumia Shell stations na authorized stockist peke yake. Whether empty or not, simamisha cylinder wima. Ventilation muhimu. Fungua madirisha ukipika. Alafu regulator na pipe hazifai kulast forever. Replace time. Ukifanya hivyo, uko poa kuendelea kukaranga bila wasiwasi. Tuwe safe jikoni. Shika tano.
Indeed, safety with gas is easy. 1. Only purchase AfriGas from an authorized stockist. 2. Transport your cylinder in an upright position. 3. Use the appropriate regulator for your cylinder. 4. Ensure the cooking area is well ventilated. And 5. Finally, treat an empty cylinder just like you would a full one. Switch to AfriGas today. Live better. A mini AfriGas.
AfriGas.
The commission also noted that the petitioners were subjected to physical assault. They were beaten, there were physical scars on their bodies.
Yes.
The commission also noticed that before their release, the petitioners were given 2,000 to 3,500 shillings by their abductors and told that they can find their way home. They were also warned against speaking ill of the government.
Just a moment. Yes.
They were warned against criticizing the government and encouraged to make better use of their time and their digital accounts.
Yes.
We wish for the court to take judicial notice that during the captivity, the petitioners were subjected to torture, cruel, inhuman, and degrading treatment, my lord, which is one of the non-derogable rights by their captures. To date, the first, second, and ninth respondents, having taken their statements, have not tabled any report or findings before this honorable court. My lord, based on the similarities and the patterns of the abductions of the second to sixth petitioners, the commission believes that they were held by the same person or entity. And the commission also believes that the state is responsible for these abductions and the National Police Service and the ninth respondent should be held accountable for the same. My lord?
Yes.
The commission principal organ of state in matters human rights has made an observation that the state has failed in its obligations under treaties and conventions by failing to prevent, investigate, and hold the persons liable for the abductions and enforced disappearance accountable. My lord, the burden of proof lies with the respondents, and the balance of convenience, my lord, tips in favor of granting the relief sought in the application. That is all, my lord.
Yes, Your Lordship, I will be very brief. For the fifth interested party, we have filed a replying affidavit dated the 6th January 2025, and the list of authorities dated the same day. We'll be relying on that. The replying affidavit has been sworn by the Executive Director of the fifth interested party. And in it, you will note at the time that we were filing this particular replying affidavit, the petitioners had not been found. So what the interested party did was compile some evidence for the court to be able to see that there's similar fact evidence between previous abductions and the ones currently in issue. In paragraph 6 of that paragraph...
Just a moment, Councillor Ibanya.
Yes.
A moment. Similar fact.
The evidence of abductions that had happened, similar to the one that is the subject of this particular habeas corpus.
Yes.
Paragraph 8 of that affidavit, the interested party has highlighted the abduction of Mr. Macharia Gaido.
Please remind me the date of that affidavit.
The affidavit is 6th January 2025.
Thank you.
By the fifth interested party.
Yes.
Which has been highlighted to the court. Paragraph 7 of the same affidavit, the executive director of the fifth interested party himself was forcefully abducted in the middle of a protest and manhandled. Still in that affidavit, in paragraph 14.
Just a moment.
Yes. I do.
Just a moment.
Yes.
You're referencing in paragraph 7 that clip that I had initially said should not be watched.
Yes.
Mr. Guyo, please find that clip and let's watch it. Perhaps when I was declining for us to watch it,
yes,
you should have started off by saying similar fact.
Yes.
I'm not too big to say I can be wrong and change my mind, so we'll watch this clip.
So the affidavit explains the circumstances of that particular video. Still on the affidavit, Your Lordship, in paragraph 14 of the same affidavit, we introduced the evidence of the abduction of the Longton brothers, that is Jamil Longton and Aslam Longton, which has been played.
Yes.
And in it, Your Lordship, Longtons give an account again of similar evidence of how they were abducted, the broad daylight.
Council Ibanya, yes, to touch on what Council Nyamodi stated.
Yes.
That is pending before my brother, Judge. I've watched it. Please permit me not to record.
Okay, I'm not talking about the basic the clip. If you look at the annexures, we have annexed 2 affidavits.
Yes.
In our bundle of annexures, marked as HI4 and HI5.
Yes.
These are affidavits by Jamil Longton and Aslan Longton. I don't know what is before your brother. Yes. What I do understand is before your brother was on Bob Njagi, not the Longton brothers.
Yes, Mr. Nyamodi.
Or if I perhaps can be a little more explicit about what I meant.
Yes, please.
It is petition 436 of 2014. The petitioners are the Law Society of Kenya. The Law Society of Kenya. Jamil Longton is the second petitioner, and Aslam Longton is the fourth petitioner. The respondents are my clients, the Attorney General, and the National Intelligence Service. So there is a substantive petition pending. It is a habeas corpus similar to this, and I believe it would be prejudicial, similar fact evidence or not, for any of that kind of submission to be entertained.
I concede, Your Honor. I'm most directed. Thank you.
So, just for the record.
Yes.
So I'll say court. The court recognizes the pendency of petition 436 of 2024 before Mugambi J in this division, the substance of which touches on habeas corpus of 2 persons whom are referenced in an affidavit dated 6th January 2025 by the 5th interested party. The court shall not interrogate the relative merits or demerits of their reference in this matter, save as to apply the alleged similar incident question to other evidence. Thank you. Please proceed.
So based on that ruling, Your Lordship,
yes,
the affidavit of both brothers has been annexed as HI4 and HI5. As you retire, you might decide to look at that and the issues
the court shall not read or consider the next affidavits of, oh, by the way, your time is off, of the two brothers. The challenge is it's also a HB.
Okay.
Sorry.
I'm almost directed. So in closing your lordship,
yes.
I will direct you to the bundle of documents that we have annexed, the list of authorities, sorry. On the list of authorities,
yes,
we have annexed the case of Republic versus Joey Irungu and another, which is a criminal case. That is High Court Criminal Case number 51 of 2018.
Yes.
Why I'm getting to this is because I'm picking up from where Mr. Kinoti left on the Vasquez case on the importance of circumstantial evidence.
Yes.
So on paragraph 30 of that case, paragraph 300, sorry, and paragraph 301,
yes,
there is a definition of circumstantial evidence.
Yes.
And this particular definition is a bit lengthy. I don't know if you'll permit me to read it or you'll look at it yourself.
You have 5 minutes.
Yes, yes. So it says that in paragraph 300.
I mean, all the petitioners, you've done 1 hour and 24 minutes.
Okay, in the interest of my colleagues.
Yes.
I just invite the court to look at that definition. And then I will also bring the court's attention to the case of LSK and 3 others versus the AG and 3 others, which is miscellaneous criminal application 244 of 2016. This was a habeas corpus petition of the
miscellaneous 244
of 2016.
This is the one that the decision came out in 2018.
Yes, this is the one for Willie Kimani.
Okay.
The habeas corpus. So in it, the court talks about the issue of denial by the state organ that should protect citizens. And in the case, it was even found out that later that the police were actually the people who knew where the petitioners were at the time. So I'll invite the court to that particular case. I will rest on that, Your Lordship.
Thank you.
We notice that time has advanced.
Yes.
And we wish to request for 15 more minutes. We have Council Jirundegwa, Senior Aminwa, and Ogada. And we do not mind the same being done to the other side, because it's important that all the issues be canvassed. And our last issue, the command, the command and the responsibility have not been argued. We would like that you allow. Most respectfully, we have tried, but we have not been able to contain ourselves.
My concern is if you go to 2 hours and we come back perhaps at 2:30, you may go deep into the afternoon and you'll still not have done your rejoinder. Perhaps then this is a good time for us to agree on whether we need a second date. Just a moment, Senior Counsel. Let me hear from Mr. Nyamodi.
My Lord, so that we are all able to ventilate our client's position in this important matter in an unrushed manner. If your Lordship is able to accommodate us in your diary,
yes,
perhaps today we can conclude with the petitioner's case and you then give us an opportunity to proceed before you with the respondent's case.
Senior Counsel Peru.
May we make it easier? We are only requesting for 15 minutes. And if today the respondents respond and we are unable to close, then we can be given a tiny window to do that. We do not wish to prolong the matter longer than we should.
Senior Counsel, you've been in the profession for a very long time.
Yeah.
You know when advocates say a tiny window.
Yeah. Well, I want to say yes, it is true.
Your Honor, for Kituo cha Sheria, I plead with you, give me a few minutes.
Yes, I'll give you a few minutes, and it is because of that I am looking to find a date.
We agree.
Within this week? Wednesday this week?
Thursday may be better.
Thursday I have 31 judgments, 6 rulings, 4 mentions.
On Thursday we have a matter of equal intensity for your brother, Mr. Justice Chacha Muta.
Yes.
Can we come back on Friday?
Friday will be nice. Oh, full.
Friday?
I think Friday we will arrange ourselves. Those who are not able to come, others will finish the closing.
So Friday will be the respondents' case, those opposed, as well as your
responses.
Your responses. Or do we start off and see how far we go?
I think so, because we need just a few.
Well, if you are able to do it, because of the importance of the matter, and because your lordship has already assigned another day, or is minded for another day, it would be opportune if you give us an opportunity to digest the submissions that have been made and proceed on Friday.
That's no problem with that.
So this is what I can give you. Friday, yes, Mr. Martin.
We try Wednesday. No. We're done.
I would also prefer Wednesday, to be honest.
Your lordship again on Wednesday. I think we also before you for the other.
Yeah, before we Wednesday for each other?
Yeah, they are done in matter.
Isn't that a mention?
Yeah, but maybe convoluted.
Maybe Wednesday.
Wednesday is fine.
Monday
you can take Wednesday. No, Wednesday we can take Wednesday.
The only date I have this week is Friday.
Or Friday.
Friday is not available.
Let's stick to Friday.
Let's stick Friday. Friday.
Now, on Friday, I will take out 2 hearings and 2 highlightings to make space for yourself. So that is... So we can say Friday from 9:30.
I'm very grateful.
And I give 3 hours. So that is 12:30. We go for lunch, we come back. So in view of that, we have a choice. We can push on for perhaps, because I will give them 3 hours. Sorry, 9:30, 10:30, 11:30, 12:30. We'll just push on Friday for 3 hours. So you've already done 1.5 hours. Do we push on for maybe another 30 minutes? Then we come back for an hour?
Yes. Multiplied.
So we'll have another 30 minutes. Then we'll come back at, so we'll stop at 1 o'clock. We'll come back at 2:30.
So after it's coming up.
I'm being asked by my colleagues to proceed, but I think I will just rest. Let me just keep my colleagues to proceed. In view of I was rushed. I think you have the authorities. Unless you do want me to highlight something, the workshop.
Well, you'll have 30 minutes now, and then another 1 hour afterwards.
It's you.
Yes, so I'll take, who else before lunch? Will it just be Dr. Amino before lunch?
Yes.
So Dr. Amino, 30 minutes, please. Yes.
Your Honor, when considering what is happening, when us look at the history of this country.
Yes.
This is a country, Your Honor, where the executive has not had much respect for the rule of law at all.
Yes.
This happened during the colonial rule and the British were in power.
Yes.
Those who are fighting for freedom in this country
Yes.
I recall during the time I was at school, at Yolansi High School, were picked up. At any time by those in power. They were in uniform. Sometimes they were not. In other words, Your Honor, it is an entrenched culture of the country.
Yes.
When Mzee Jomo Kenyatta came into power, he did the same. People were detained without trial.
Yes.
When Mzee Daniel Arap Moi came into power, he did the same.
Yes.
People were picked up and detained without trial. There were some were detained at night or were picked up at night during the wee hours.
Yes.
Privacy was unquestionable. I was personally a victim. I was detained twice. You were picked up by people that you did not know at all. And within a few hours or few days,
yes,
you found yourself at Hola, Manyani, Manda, Irons, Naivasha, and etc. So, Your Honor, when one comes up with the arguments of my able and friend, Mr. Moni, that you have to prove something and so on, Your Honor, that is not necessary at all.
Yes.
We live in this country. We know what is going on. And it does not try to pretend that we do not know what is happening, who is doing what. It is known, it's common knowledge. It is the executive, it is the government that is doing all these things, or picking up people. Your Honor, to be able to pick up to abduct people,
yes,
you need an organization, individuals who have been trained. You need to have arms, AK-47 or other arms and so on. You need to have vehicles. It is not something that can be undertaken by ordinary individuals at all. These are organized people who have the blessings of the government. And indeed, when His Excellency the President spoke, it was quite clear that he was in know-how of what was happening. I listened to his words correctly. And if you listen to his words correctly, when he spoke in the presence of the Right Honorable Prime Minister, he must have known what was going on. Your Honor,
yes,
the arrests have a certain pattern. The arrests have got certain similarities. There's a doctrine, Your Honor, when you were still young, at the University of Jurev, when we read the law, is referred to in Latin jargon, res ipsa loquitur.
Yes.
Your Honor, what has happened speaks for itself. And it doesn't waste the time of the court, this court, the district court, going into technicalities and what and so on. No.
Sound Candy Talk Live News. At Sound Candy Talk, we help your event, trainings, shows, and so more to the world through internet broadcasting in UHD. We provide from 1 to several camera setups and integrate graphics to live in your live streams. For more information, contact us through +2547 18454585 or email at soundcandytalk@gmail.com. Reach on us today. Mimi ni Shadizo na kutakia Happy New Year. At Sound Candy Talk, we provide live UHD broadcasting for church services, talk shows and podcasts, weddings, live bands, products and services launches, webinars and trainings, Zoom meetings, conferences, seminars, exhibitions, and virtual concerts. Kutoka vijijini, mijini hadi jijini. Hii ni Sound Candy Talk Live.
Kwa nini mwasema Ruto aendelee? Na hali kabla Ruto hajaingia, Mkenya alikuwa kila mara 3 kwa siku. Wanwa chai asubuhi, wala saa 6 na jioni, walala kama wakorota kweli kweli. Lakini leo kinwa turungi asubuhi mpaka jioni. Tena jioni ni hamna, sima na chumvi ama na mboga za vichochoroni. Bwana Ruto amewatesa Wakenya pahali ambapo pamepita kiasi, na yule anemtetea Ruto nafikiri ana akili punguani.
Unatazama Sound Candy Talk Live.